The DA has vowed to oppose an application by the ANC to have the Electoral Commission of South Africa reopen its candidate list system for the upcoming local government elections. Now, this also comes after the ANC missed the Monday night deadline to file all its candidates, citing, among other things, technical glitches. ANC Deputy Secretary General Jesse Duarte on Thursday confirmed that the party had approached the Electoral Court to have the IEC reopen the list. Joining me now is Werner Horn, the DA IEC representative. Mr. Horn, a pleasure to have you on the program this afternoon. Now, you referred to the move by the ANC as a frivolous application. Tell us why.
Good afternoon. Yes, in our view, it's quite clear that any deficiencies in the ANC list process and the submission of their candidates was caused by themselves. We've taken note that they now claim all sorts of technical deficiencies in the IEC process. From our side, we experienced no technical difficulties. I think no other parties have claimed technical difficulties. And our assessment is that in all likelihood, the ANC left it too late to start capturing the detail of their prospective candidates on the system. As it is, it's in the public domain that they had the NEC only approve their candidates lists over the Saturday and the Sunday. And quite frankly, I think to leave it till the Monday, which was the last day for submission of candidates lists, just simply left them without time. In addition to that, if you listen to Mr. Duarte's input on Tuesday, it's also quite clear that the ANC did not realize that they had, from their side, had to check whether all of their prospective candidates were registered correctly in the municipalities where they wanted to field them as candidates. So in that sense, it's quite frivolous. There's absolutely no reason why either the Electoral Commission or the Electoral Court should assist any party who failed to do whatever they needed to do in a timely manner.
Now, other parties, including COPE as well as the EFF, have also raised issue with the ANC's application. Are there any practical steps that you are planning to take as the DA to challenge the ANC's application?
Yes, well, we firstly expect to be cited as a party in the application, given the fact that we have registered to take part in the elections and have filed our lists. And then we will definitely, from our side, put on record, alert the court, remind the court to the previous findings in 2011 when the IFP was precluded from taking part in certain municipalities, and in 2016 when the NFP was precluded from taking part at all in the local government elections for the reason that they did not meet all of the requirements by the time that the cut-off date as stated in the IEC's timetable came. And both those parties at the time took the matter to court, and our courts were quite clear in saying that the timetable is the product of electoral legislation, and a strict adherence and enforcement of the timetable protects not only the independence of the Electoral Commission, but also is a vital part in ensuring the integrity of the process and ensuring free and fair elections. So from our side, we will take those legal precedents back to the court, and we hope, of course, that the IEC from their side will also oppose the application and bring to the court the information they should have to the effect that their system was not malfunctioning, but as a matter of fact, functioned perfectly up to the 9 o'clock cut-off time.
Now, of course, there are implications. I just want to get a sense of what does this application mean, considering that the IEC is also seen to uphold a high standard of credibility.
Yeah, look, the application will basically, as I indicated, ask our courts to set aside previous legal precedent. In addition to that, I believe the Electoral Court would not be in a position to hear the application in the absence of the Constitutional Court's judgment in that application of the IEC for a postponement of the election. So the Electoral Court, in my view, would not be able to deal with the matter until that judgment has come. And as a matter of fact, until the Constitutional Court has come out with a directive that the election must proceed on the 27th of October this year. So there's lots of hurdles to be passed. You're quite correct. Of course, the way the Electoral Commission will react to this application will also once again be an indication as to whether it is willing to bend to the pressure and significant pressures of the governing party, or whether it will stiffen its back and just stick to the timetable as gazetted. As it is, in any event on the 23rd, extended the cut-off time from 5 o'clock to 9 o'clock to assist political parties who struggled to meet the deadline. So it's not as if the IEC totally turned a deaf ear to the pleas from political parties on the day. But once again, everybody has to remember that at least from the 6th of July this year, all political parties knew that the 23rd of August was to be the final date for submission of candidates lists.
But I'm sure you'd agree that we also have to consider an opposing view. Now, there is also this view that if the IEC system goes without being properly scrutinized, this may also open the Commission to being accused of failing to hold a free and fair election. What is your response to this view?
Yeah, well, certainly, and that's why I strongly believe that the IEC's electronic system will have in place a proper backup, the type of backup that will allow the IEC to put in front of any court a detailed analysis, a detailed virtual footprint of all political parties who make use of the system. And in that way, the Commission should be able to rebut any claims that the system froze or that the system rejected ID numbers of candidates which should not have been rejected. The system is not a new system. The system has been in place in the 2019 election as well. And once again, from where we're looking at it, even though we finished the submission of our candidates list much earlier on the Monday, we did not experience any problems with the system failing us.
I want to touch on an aspect that you alluded to a bit earlier on in our conversation, saying that the DA also holds the view that for the sake of consistency, the IEC should vigorously oppose the ANC's application on the basis of the past precedent. I mean, you did recall how the IEC previously barred candidates from the NFP from contesting the 2016 local government elections. Let's reflect a bit more on this and explain how you plan to use this particular opposition to strengthen your call that the Electoral Court should dismiss the ANC's application and that this precedent has already been set.
Yeah. So look, in that case which the NFP made before the Electoral Court in 2016 on an urgent basis, their argument was that to exclude them from the ballot would render the elections not to be free and fair, given the fact that at that stage they had a good footprint, at least in KwaZulu-Natal. And the court in detail dealt with that specific argument and actually flipped the whole argument on its backside by saying that in order to protect the integrity of the processes, it would be unfair to those parties who put themselves under tremendous pressure to meet all of the IEC's deadlines and did so successfully. It would be unfair to those parties, as a matter of fact, and those parties would be able to complain about being treated unfairly if the Electoral Commission, or the court for that matter, allowed for those who did not stick to the deadlines and the cut-off dates and times to then enter through the back door at a later stage. So that is the legal precedent. As I say, unless the ANC can come with very clear proof that the IEC system failed on the day, I can't see on the back of that precedent that the Electoral Court will ultimately be able to assist the ANC in any way.
But if the Electoral Court does indeed rule in the ANC's favor and offer to assist them, like you put it, what kind of precedent do you think this would set for the electorate?
Well, a very dangerous precedent, in the sense that then from there on, obviously every party who, even if it's for its own making, feel that something contained in terms of the obligations parties have, as reflected in the timetable, did not suit them, would be able to then plead to the court for assistance. So in that sense, Lady Justice must really be blindfolded, in our view, in this matter. It should be of no significance that it is the governing party or the party that governs the vast majority of local governments in South Africa. We've heard that 35 municipalities are affected, and it's quite clear that in a large number of wards, in terms of the current state of affairs, the ANC will not have candidates. Ultimately, in our view, all of that is irrelevant. And if the principle is to be upheld, then voters will simply have to make a choice between the myriad of other candidates that will be on the ballot.
Well, that was IEC Representative Werner Horn. He says that they'll be opposing the ANC's application to reopen candidate nominations, and they say that the move by the ANC is just a frivolous application.